is Sam Ryan Hidari, the host of the Sex, Lies, and Lawyers. We are here with another episode of the Sex, Lies, and Lawyers. We have a very dear friend of mine, Jon Orlando.
I like
here.
that. The dear friend. I graduated.
Thank you. Yeah.
Dear friend status. I like that. I'll take it.
How are you doing today?
I'm good, man. I had a good time last week at your grand opening.
Thank you for coming over and support.
I don't know what I pictured, but it wasn't that. It's beautiful. First of all, I pictured like an old office building, and you found the coolest building. It's like I don't know what it was. Was it once a house or something?
No, it was a law firm before.
It was?
Yes, it was a law firm. It was a commercial building. We just remodeled the entire thing outside, inside, within 2 months, actually.
It looks amazing. The decor, I was just blown away. The sign, how the sign was backlit, and then the sign in your own office, you have that sign, like the furniture. I loved everything. I thought it was really cool.
Thank you.
It was good.
Yeah,
you didn't pick out that furniture though.
My wife.
Your wife
and
did.
My friend. Actually.
Your wife loves me.
Yeah.
I'm her favorite. I'm her favorite person.
You are the most favorite.
First thing she says is
favorite
like,
and the wanted on the list.
she's like, no more hot girls. I'm like, the show's called Sex, Lies, and Lawyers. What do you want? She's like, no more of that. Change the name.
That's your problem with her.
That's my problem. Yeah.
I'm coming here and just manage.
You got me in hot. Well, I wasn't at that party. I hadn't taken 2 bites of food yet, and she comes cruising up to me.
Down.
You're Jon Orlando. Yeah, I need to talk to you. Pulls me aside, smacked me around.
Why is this Sex and Lies and Lawyers? It should be something else.
Yeah. And then I threw out sample names to her. I was like, okay, how about Hookers, Lies, and Lawyers? That didn't go over well. She didn't like that. I couldn't get her.
She's so conservative.
Yeah,
she doesn't like the name.
Yeah.
I don't know.
Yeah, it was funny. And then Dr. Leslie was at the party as well at the grand opening, who's already been on the show. So I said, what about her? She's a doctor. And she's like, nope, too hot. No good.
Really?
Yeah.
I didn't notice that.
Yeah. So then you weren't there for this, were you, George? Did you hear all this?
No.
This is all true. Yeah. And so then I pull up on Instagram, I pull up Vanessa, my girlfriend, I pull up her page. I go, how about this girl? And she's like, no way, too hot. And I go, that's my girl. She's like, I don't care, too hot, no good.
Man, I don't know what to do. It's your fault.
And your wife looks like a supermodel herself, so I don't even understand what the problem is.
That's
but
the reason. I don't know. She doesn't.
There's
want
only
anyone
room
around
for
me.
one supermodel in this city on this show, and that's her.
That's Niloufar.
Too funny. But I wanted to ask you. So I've got questions for you, Sam, because it dawned on me when I was at the party. In my head, I've known you now, I don't know, 6 months or whatever it is, and obviously you're a very successful attorney.
Thank you.
But it wasn't until I went to that party and I looked at all the people there and a lot of people working for you and the different offices. And I know you have how many people that work for you in LA? How many lawyers?
In LA, 40 people, staff, and 10 lawyers.
Right. Okay. So you're actually, call me stupid, but you're actually an entrepreneur. I didn't realize, I just, in my head, oh, you're an attorney, you're a lawyer or whatever. But I wanted to talk about all the different pressure that comes, because I feel like you almost have a double life, right? You're an attorney on one side, so you've got all that stress where you got to deal with all the different cases and trying to, fight in court and win for the clients. But then also you're a boss, you're an entrepreneur, you've got employees, you got that's a lot of stress, right?
Also, you are a customer service, provider of customer service, because we do only on the contingency fee agreement. It means that clients can leave us at any time.
Right.
If your customer service is not good, your staff are not returning calls, or they are not giving updates, your attorneys or myself are not reachable when there is an issue for the client, that I can go anywhere else and I'm not getting anything.
Right.
So that's a stress. I mean, is it like a full customer service plus litigation and the pre-litigation and the trial? And also at the same time, you have to deal with the experts, you have to deal with the vendors, you have to deal with everyone. That's not the one aspect to say, hey, it's just litigation, or it's just pre-litigation, or it's just staffing. You have to deal with all of them.
So how do you do that? How do you manage both sides of that?
It's with the help of the office manager and other people, but I have to get reports every week. When I come to Vegas, 2 days, 3 days actually that I'm in Vegas, I get the report about the marketing, about the litigation team, pre-litigation team, marketing, admin, meetings back to back that brief me as to what's going on, what the plan is, and meetings from morning till afternoon with the vendors, with the marketers, with the experts with the clients that they
Right.
wanted to meet me. So in 2-3 days, actually, my schedule is full completely when I come to Vegas on Tuesday, Wednesday, and Thursdays.
And you say the marketers, that's because like your space you're in is so competitive. There's so many like if you drive down just the 15, Interstate 15, there is nothing. If you could probably go from downtown to like the South Point Casino and see, I don't know, there's probably
Multiple,
15 billboards.
Billboards about the personal injury lawyers. Or
Right.
the
So
people that they practice.
you're all fighting for the same pool
Same
of
pool.
people that got injured.
That's exactly the thing. But having a billboard is different. And practicing law, sometimes I tell people, in the car accident, people think that it's easy to make the money, and some of them, they look at the pre-litigation situation, they send the demand, they get the money, and they never litigate. But rarely you see those people, they go extra miles and go litigation, or you transfer the litigation to other firms that they share the attorney's fees with them, and less motivation for the litigators. That's the reason that I keep everything from pre-litigation all the way to the end of the trial, even sometimes the appeal in-house, makes us motivated, and my lawyers, to just litigate and advocate for the client. Is they don't look at the attorneys and say, oh, 50% goes to the firm that referred it to us.
Right.
It's all ours, and we fight for it, and we get it for the client. The more we get for the client, the more we get for ourselves.
Right.
And we are not sharing the attorney fee with any other litigation firm or a trial firm. And we make whole, clients makes whole. That's the reason that, a lot of people get into this business because they think that it's easy, and they do pre-litigation and they sell the cases for low amounts, just whatever comes to the desk, and do a mass production. A mass production is easy, but
And that's just trying to get people to settle. Just trying to
get the money and get the settle
for
away.
25 grand,
Always,
50 grand.
Settlement is good, but not always. Insurance company, after a while, they know that you are a seller. It means that you sell your cases. You don't litigate it. They start lowballing you.
Got it.
They say, just take this. Instead of the 100,000 or million, take the $500,000.
Right.
That I send it to you. Or instead of the $25,000, they give you half.
Right.
$8,000.
And over, how many cases a year would you say you do? Is it thousands?
Right now, we have around 1,400 open cases
Wow,
in Southern California, California and Nevada.
So just selling low is a big difference than if you just saw it through.
The cost is high, actually. It's not something, but having a lawyers in-house, actually, and being as an employee and not on the percentage to get motivated to work on the cases. There are other business models for some law firms. They say that they are partners, or they are actually, they tell you that they are employees, but they are contract. They get the percentage. They don't get salary out of the firms. It's not. My business model is not like that. They are the part of the firm. They
So that's what I was going to ask you.
So law group. They are not going to be based on the percentage out of the case. They get some percentage as a motivation and a bonus, not but selling the case because my boss wants the money. Right. And we wanted the bonuses. They are well paid. They try it. They try to litigate it to the end, and they don't sell it for less.
Right. So that's a lot of stress. That's where a lot of stress comes in, right? Because you're paying
the overhead is
you're
high.
Paying salary to the attorneys that work for you.
And you have to manage this.
But you're taking cases on for free until
they settle,
you win, until they settle.
Yes.
So you're really exposed
a lot.
Right.
And sometimes the expert in one case, it takes around $150,000 to $200,000 expert till you try the case.
To pay the expert.
And who pays that? Our firm pays it. And if we lose or win, that's the money that we spend.
Right.
So our expert funds possibly is the millions of dollars of expert fund that we have to litigate the cases and hire experts. Most of the firm, when it gets to the expert, they give it to someone else, or they just sell it. The time that they have to designate expert to advocate for the case. They file, but they go all the way to the time of the expert or 2 months before that and say, oh, let's give it to someone else. We don't want to spend that money.
Right.
Because the retainers are expensive. Each expert, $5,000, $10,000 just to review the documents, $20,000. You get easily to $40,000, $50,000 within 60 days before the trial, or 75 days prior to the trial, after the expert designation for your case. That's a huge burden on the firms. That's the reason that you see some firms, they do only pre-litigation. Mass production, they take cases and they sort it out, they send it out to the other people. Some people, they just do the trial and the litigation for those firms.
Okay.
Rarely you see that firm does both.
Right.
in Nevada or California specifically. That it takes a while because it takes money, it takes time, it takes management, and you have to be so organized not to miss deadlines.
Yeah.
Manage the attorneys, 10 attorneys to manage. Still, you think that attorneys, they don't need management, but no, they need management.
And that was the next thing I was going to ask you is you have your own caseload that you're personally working on cases.
Yes.
And then do you have to touch all of the cases at the office though in some
I get
capacity?
a report. I get a report from the lawyers every 2 weeks, and I ask them what's going on. Brief me as to what this going on is, what the strategy is, who is deposed, what the discovery is done. Give me the facts.
Right.
What's our last offer? What's going on? What's the plan for the trial? Who we are going to depose? They have to have that briefing for me as to the cases. Every 2 weeks, one of the lawyers comes in and brief me as to their cases is allocated to them. Then if there is a need for another associate to take over or senior associate to take over, we allocate it.
And do you help them out with strategy too, I would imagine?
Of course.
Yeah.
I monitor my cases fully.
Right.
And I know my clients.
Right.
All the 400 cases in litigation, I know them.
That's how many there is like right now?
I have around
Between
400.
LA and Vegas?
Yes, 430 in the court cases that are active litigation.
Wow.
Yeah.
And how many days a week are you actually in court?
It depends. If it's a trial, for example, on Monday I'm starting a trial, it's going to be around 7 days to 10 days, back to back every day you have to go. But there is
9 to 5?
8:30 to 5 and break in between, but you have to go and present the case to the jury. But as to the motion hearing recently, they are mostly by Zoom or the Blue Jeans, actually in California and Nevada. And you attended by Zoom. I'm also a lawyer that it saves a lot of money for us, specifically because we don't get paid hourly.
Right.
And the depositions are by Zoom, most of them.
Yeah.
Recently, before you should have gone or send your associate to somewhere to attend the deposition.
Yeah.
Now you do it by Zoom. Everyone is by Zoom. Or they had to come to your office. You are a shortage of the conference room. 2 conference room was not enough because you were having 3 depositions at the same time. Now it's so convenient and is more efficient for the plaintiff side. Defense side, they love that because they go out, the insurance company pays them, they drag the case wherever, and they go, even the travel time, it counts at their billables.
Really?
Yep, that's the thing. And it's beneficial to us because we work on the contingency fee agreement.
Right.
It means the faster, more efficient we bring it to the resolution.
Yep, the better for you.
It is better for me because sometimes attorney fees comes up with $1,000 per hour that you expended if you break it down based on the average on the case. Sometimes it's $20 because you spent a lot of money and you didn't recover anything because you hit the empty pocket or something.
Yeah.
And that's the thing. That it's a little bit of stress. You have to manage the cash flow in the personal injury firms, and it's not easy to start. You have to survive on a year and a half, at least on your own, and pay the employees and expand little by little. It takes a while. And
one case can be a game changer, good or bad, right? Literally, one case could sink you, and one case could just make your whole life.
It depends on how much you spend on the case.
Right.
It never sinks you unless you spend $2 million, $3 million, $5 million in costs in it or drag it for it. Those are the big cases, the product liability cases. But usually the cases, either you win or you lose, or you recover low verdict, then you have to appeal to see that what's going on in the case because some situations. Overall, it's a risk involved. That's the reason they say the attorney's fees is contingency and it's higher. There is no hourly. To use your creativity, actually be creative as to what you want to do in the case, strategize it and make it faster, more efficient to make more money.
Right.
It's beneficial to us. Sometimes the client says, why are you taking too long? You say, you think that I like that to take it too long? No, it's litigation because it's not the fair amount that for your damages. You end up with the low money or for damage, it's not the fair compensation. And if it's some other lawyer tells you that, they can close it fast, they're lying to you.
Right.
Because there is a disputed liability. There are a pre-existing condition in the back, and they are blaming the causation to something else. There is no way. If you want to sell less, yes, you can just do it, and if you are happy, it's you are the master. You are the person who pulls the string. But I'm telling you, it's not beneficial to you. Sometimes they ask, oh, why is it taking that long? You say, and after a while, they stay and wait. They will see the result. They say, oh, man, I couldn't believe it. You told me. And say, yeah, I told you, be patient, do your homework, and it's first your health, and you get your fair treatment, and you get the fair damages, actually, reimbursement for your damages. That's the thing that some people, they think, oh, you are dragging because you get more money. Say, yeah, but I get more money, you are getting more money. It's mutually beneficial to both of us. It's not something, and that's it. And sometimes they say, yeah, sometimes I tell the client, don't drag it anymore. You're going to lose.
Yep.
It's better to sell it, take it. And someone say, no, I want to fight it. I want to go all the way. And say, I'm not going all the way because I know that I'm losing my $100,000 cost.
Right.
Not my attorney's fees that hourly that I spend, my associate time, my paralegal time, all those things. In addition, I'm going to lose the expert fees.
Right.
And all those things. And then you are going to pay? It's not reasonable for me to go. No reasonable lawyer is going to go try that case because it's crazy, because you lied on the record, for example, and it's contrary to what you tell you. Exactly.
Right. Did you see the movie Aaron Brockovich?
No.
No?
No.
Oh my God, you got to see this movie. It's
What's
a true
about?
story about I might mess this up exactly, but it's with Julia Roberts. It's old. It's probably 15 years old.
Seen it.
She's a paralegal, or like actually not even. She's like an assistant, just at a law firm. And it's a true story. They ended up suing a power company, like the power lines in this neighborhood.
Pacific Gas Electric. I'll fill in the blanks.
Yeah, yeah. So they all these people that lived in this neighborhood, they were getting cancer because they lived in houses near the right underneath the power lines, whatever. And this girl, Erin Brockovich, she went and brought the case to her boss, to the lawyer, and he was like, we can't go up against a big company like that. We're a small law firm, like you can't do it. She went and did all the research and like talked to all the, all the victims and their parents and the, all that stuff. And they ended up winning like a huge settlement. I want to say like $500 million or something crazy. There you go. I got it all wrong.
$133.6 million.
What year?
Settlement. That says 1996.
Whoa, wow. It was a lot of money.
Yeah. You should watch that movie though, Aaron. I'll send it to you.
I think I remember that movie.
Yeah.
I watched it, but I don't remember the name.
But that's what I was going to ask you is, have you had any class action suits? Have you done any of those or no?
Because
those are massive, right?
Sometimes in California, we do PAGA, is like a class action in the employment.
Yeah.
For example, one big corporation is starting to just taking some hours or miscalculating the wage and hours. You can act like an attorney general and go in the shoes and bring the class action on behalf of all the similarly situated people in that company during that time period that they were short on the payments, or they were having the brakes problem, or they are not paying. That's yes, we do. PAGA. They call it PAGA in California, but there's no such a thing in Nevada.
You popped a button on you're exposing yourself. See, it's sex, lies, and lawyers. That's the sex part. I wonder what the wife will say to that. Listen, I'm sending girls here. They keep their clothes on. You're taking off your clothes.
I'm not taking off. I don't know what happened. Okay, don't blame me.
What's the fun part for you? Is there a fun part? Like, is going to trial fun?
It's fun. It's sometimes is tiring. It depends on the counsel on the opposite side. It depends on the case. Depends on the client. There are a lot of factors going to the trial or having litigation. Even sometimes taking the position is fun because you are exposing some parties or the big corporation as to how scandalous they are, and they lie on the record as to what their position is at this case, and then you ask us to the other case and say, hey, what about if this goes out and become public in this deposition? You are still advocating for that? Then all those people can come over and claim it. Say, yes, but I know that they're fighting so hard to keep that confidential because he admitted something on the record, the person most knowledgeable of that company, that is going to damaging to the other cases, not that case in hand at that time. And they do that.
Do you ever have such a good deposition? It goes so well for you that you crushed them and they just wave the white flag. They're like, we quit?
Motions to come out that this confidentiality is going to be removed, and then to see that what happens. But I cannot talk about it because that deposition is confidential and protected by the confidentiality agreement. But since there is a public interest in it, we are going to ask for the court to designate it as non-confidential, those parts, and then it can come out and other people can use it against that corporation.
Wow.
Yeah.
So, and you may not be able to say like the exact name or whatever, but like, so for Monday, the one that's going to trial, what type of trial is it? Like what happened? Could you say that?
It's a car accident. Our client was a passenger and had the pre-existing issues. She was transported to the hospital after the accident, and the insurance company of the driver in the back settled the case with the two passenger in our vehicle and the driver, and forgot about our client. They never called our client, even though she was transported and her name was in the police report. And it was very interesting that she transported, she had the same cell phone, and the insurance company of that person that rear-ended our client settled the case, offered the $25.50 to 3 people inside without contacting our client or contacting our firm. Later we found out and say, hey, you have to settle this case with us. The bills are $60,000, $70,000 and tender the limit. They said, oh, $13,000 is left. I said, dude, you were not supposed to do such a thing. You should have done a due diligence to contact us or contact the client. They say, oh, we didn't have the client's contact. They say, it's on the police report. And then they say, oh, the phone was not working. I said, this client has been my client in California. This phone number has been there for 8 years. And I called that in front of them and say, hey, you see that she's picking up. So don't lie. So I will give you opportunity to tender the limit again by Friday. And then they didn't.
Wow.
It's silly, yeah? It never escalated.
So you've got them, they're dead.
Now the policy is open. There's a concept that if they didn't act in a good faith or they committed a mistake in adjusting the claim, which is they settled it with the 3, they forgot ours, actually, our client. They have to pay. There is no limit on the policy anymore. It's called open policy. Now we can get the verdict $1 million, $500,000, $2 million. They have to pay. There is no limit, even though the policy was $25,000.
And this is the insurance company that you're up against.
Yes, always.
Which, right. Yeah, I guess so.
Because we represent the plaintiff, in this case, who was not at fault.
Right, but in this case, the insurance company made a mistake.
Made a mistake in adjusting the claim.
Right. So that's a little different than right.
But now they have to defend the insured anyway. But hopefully they advise their insured that they made a mistake. And if there is exposure to the verdict of the $500,000 or $1 million, that person is responsible.
Wow.
If they hid it from him, there's another bad faith for them. They acted in bad faith.
It's always trial by jury?
Yes.
You want that, right?
Yeah, always. You don't want judges to decide your case on the facts.
Right. No, does anyone ever do that? Is there ever a judge?
It depends.
Just a judge? Traffic stuff?
Traffic. If you go to a federal court, for example, and your defendant is a post office, it should be decided by the federal judge because that's a rule. There is no jury right. That's the way it is. There are some exceptions in the federal court, not the state. But a state court, only the family law is not a jury, and probate is not a jury, and family law. These are the things. Some of the special courts that they don't have jury, and by the Constitution or by the state constitution.
When you watch TV or movies and there's courtroom drama scenes, is it ever like that?
No, it's not.
Never?
No. Sometimes it is. It depends on the case.
You're never like pointing at the, did you or did you not? You're never doing that?
You do.
Yeah?
You do sometimes.
You get heated in there sometimes?
It depends on the jury that you are dealing with and they are bored or not. Sometimes you want to wake them up. You don't know. Or get their attention. You do. But not yelling at someone, but just make him to sweat on the seat, hot seat. Yes, as an expert, that they are just lying up to ears actually as to everything is pre-existing on the 32 years old that got the surgery because there was another accident 10 years ago. So of course the jury is not going to, but that's a
and are you ever going off on a rant where they're saying like objection sustained and you just keep talking? Did you ever do that?
You have to do objection. Over and over? It depends if you wanted to preserve it for the appeal, you have to object, but the judge is going to overrule or sustain. They have to change the question. Always you have to stand up and say objection, foundation. Yeah, you have to object. If you don't object, later you don't preserve it for the appeal. there should be a ruling by the judge as to each objection that you do when
And
there's
then-
a testimony.
Is it again, I just know from like movies and stuff, but like sometimes they'll say something. Actually, I've even seen it on like when I watch Court TV, well, Court TV is not even a thing anymore, but when
Judge
it was,
Judy.
yeah. So like they would say something, and then the judge will say, the other side will object. The judge will sustain it.
or overrule.
And then they'll say like, jury disregard that. But sometimes you guys say that knowing. You just want to put it in their head, even though you know it's going to get thrown out, right? I'm not supposed to ask you that.
Yeah, by ethics, you are not going to poison the jury. You are,
Right.
If you do it intentionally, sometimes the judge is going to pull the defense or the plaintiff to the sidebar and telling, hey, if you
Right.
do it one more time, I'm
Right.
going to sanction you.
But sometimes they get it in just a minute.
Sometimes they do, lawyers. I cannot deny it. Sometimes
Yeah.
they do, and they are hurted. The cat is out of the bag. Yes?
Right.
And it depends. Sometimes it causes a mistrial. If it's so egregious that it's going to poison the jury and you cannot rectify it by the jury instruction to tell them don't pay attention to that, ignore that fact, and is super prejudicial, it becomes an appealable issue. Later, they can just reverse the verdict based on that. It depends if it's a harmless error or the
Right.
non-harmless error. That's the thing.
And you're always working. You always take the cases where you know that it's the person really was wronged or the person is
they were
innocent.
injured. And
Right.
we do. Sometimes it's a 50-50 or a little bit more.
Yeah.
Anyway, in Nevada, you can just get compensated as long as you are not more than 50% at fault.
Mm-hmm.
If you are 30% at fault, still you can recover your damages in a tort, means that the car accident and the malpractice, up to 70% of your damages, whatever that the jury awards, then they multiply it by 70%, they give it to you. But if you are even 1% more than 50%, the jury finds you at fault, you don't recover anything.
Wow.
It's contrary to California. California is a pure comparative jurisdiction. It means even you are 90% at fault, still you recover 10% that you are not at fault.
Really?
Yep. That's a very interesting difference between the California negligence law and
Remember you had Evan on. Evan is my realtor, and he was in a
Yes.
bad car accident. You had him on the show. So his dad got in a car accident like 2 weeks ago or a week ago. Gets hit by an 18-wheeler. Doesn't go to the hospital.
he is a macho. No, he doesn't want. He's a strong guy.
Didn't want to go. Thought he was okay. Next day, now he's in all kinds of pain. And I'm like, what are you doing?
he's not going
Call
to the-
Sam.
Yeah,
Call Sam.
That's an interesting thing. Some people they think that it's bad to claim, but
Right.
the issue is if you don't claim, if you don't treat, and later down the road in 6 months, you have
Right.
up
Which
to
happens.
2 years to file or claim. But
Right.
insurance companies, they love the people. They say, I'm okay. They call them and say, hey, how are you doing? I'm okay.
And
I'm
now it's
good."
on the record.
And
You
it's
said
on
you're
the
okay.
record. I'm okay. And after 2 months, they say, oh, man, I cannot just wake up. I cannot just move my
Right.
shoulder. I cannot, and the limitation, the shoulder movement, neck or something.
Right.
And
Can
then
you overcome that as the attorney when they're on the record
it's
saying
so hard because the common sense is
you didn't go to the hospital, you said
didn't
you're
go to the hospital,
okay.
You're okay. So
now you want money?
and what they do, they say is attorney motivated. That's the thing that the opening statement of the defense, they say everything is attorney motivated. You didn't go to the hospital. You said that you are okay, and all of a sudden you hired a lawyer.
Right.
You went to the hospital, or you went to the doctors.
Right.
So you are lying. They are not saying, but impliedly in front of the jury, they are going
Sure.
to
It looks like a
paint
money
that
grab.
picture in a money grab. You are a money grab. That's
Right.
it. And you are lying because you were not going. As a common sense, if you are injured, you go to the urgent care. If you are common sense, you go to your primary doctor.
So for you, do you like the challenge of taking a case like that? If it
Sometimes
is
I
legit
take-
and the
it's
person
a
really is
legit and
banged
they're
up?
really banged up, and they can just testify as to it. Some people they take Advil, the other stuff
Right.
at home. Yeah,
Right.
And it's natural. People understand it. On the jury, say, yeah, everyone doesn't rush to the.
Right, and your
ER.
adrenaline,
Yeah.
it's like getting in a fight. You know, you don't realize you're banged up until you get home a few hours later. Like, oh man, this hurts.
Last Monday, this Monday actually, we had the jury selection in Santa Monica, Department D, and one of the jurors was talking actually when we were doing a voir dire. Hey, have you had any accidents? Say, yeah, I had an accident 35 years ago, and I had another accident 5 years after. I said, which one was worse? I said, the second was worse, and my car flipped in Pacific Palisade 3 times.
Oh, wow.
And I came out of the car, no scratch. I said, what about the first accident? I said, that car accident, it was not my fault. It was a major rear end. I flipped over again, but my back hurts from that accident still.
Wow.
I never claimed it, and I regret it. So that was a very interesting thing. That it shows that you can just get hit by a truck and you are not injured. Sometimes you get hit by a truck and you are a wreck, or it's a minor impact.
Right.
It hits you and your neck cracks, and if you have a pre-existing condition, it's going to be aggravated and it becomes painful. And if it doesn't go away, they are responsible for it. But always the insurance companies and defense lawyers say, oh no, it was no visual damages. It depends on the position you are in the car, depends on the body. Each body is different from the other bodies. Someone is athletic, actually some people are just susceptible, more susceptible. It's like an eggshell. You can just put the finger on it, it breaks one person, and then another thing is not the egg, it looks like an egg, but you smash it, it never breaks.
Right.
So it depends on the situation, where you are standing as a person and your body and the condition. That's a thing that people, they have to understand it on the jury. You are telling me that your friend's dad is a 2 months? Yes, I take those cases. But they have to go into the doctors and document everything and the testimony. And those cases become litigation.
Right.
Because there's a gap. They're saying, oh, your client is lying. Till they take the deposition of your client and explains to them that he was in pain, he doesn't want to go, he's that kind of personality. And the witnesses, the family or at work, he was just got off early. They know that he had pain. Then it shows, no, this guy was really injured. Then that gap is a natural gap, 2 months, 3 months. But it cannot be 6 months because no one just get injured and never goes to the doctor for 6 months if it's that excruciating.
Right. Have you ever had a case where the person is in the right, you believe that they got hurt or whatever happened, but you're representing someone that's telling the truth, and they just have a meltdown on the stand, and they're not good at that like my mom would be a perfect example. My mom's the most honest person ever. My mom would have a meltdown on the stand getting cross-examined.
Mostly honesty is not an issue because if they are not honest, I don't take the case.
Right.
The first impression they make on me at the sign-up.
Yep.
Yes, if they are not telling the truth, it's better not to sign them up if you want to take it to litigation, especially if there's disputed liability or pre-existing condition that you wanted to prove to the jury, because they are not. I don't believe it, jury is not going to believe it.
Right.
Why you have to waste your money and time, and you are so as to whether they are lying or not lying. But usually you have to give a benefit of doubt to the client and say, hey, he's not lying, but you can lie. The meter goes off.
Sure.
The alarm that she's lying. You don't take it. The issue that we deal with is they lose their temperament sometimes because the defense trying to impeach them or talking and accusing them of lying, painting them as a liar. They say, oh, you went to the prior doctors, you said that, now you are not saying that. And you went to your primary doctor, you didn't say that, you said that. And they just get freaked out because it's embarrassing in front of the jury. Someone impeaches you and they think that they are painted as a liar. That's their job of the defense. Always try to show that this lady or the guy is not credible by impeaching you on everything that is possible, even if it's not relevant. If they ask you that question, have you ever gone to the gym? The gym actually after this accident? Yes or no. Yes, they say no. And then they go subpoena the gym record and they look at it.
You're there 5 days a week.
That's the reason I tell the client, don't lie or don't say anything if you don't remember. They say, I don't remember. Don't create facts.
Right.
You are not obligated to answer the question, yes or no. If you don't know, you don't know. But when you say
it's
that,
not a crime not to know.
No, exactly. And if you don't remember, you don't remember. If they ask the question 10 different ways, if you don't remember, you don't remember.
Yeah.
Why you feel that some people is automatic? I do the same thing in a deposition. You want to look at the person thinks that they have to continue talking and say something. And you look at them, you nod your head, still they think they have to say something, and they spill more. They spill more and more and more and more, and then you get the fact, oh, okay, so what was that about? Then you start expanding on it and say, man, if you don't know, just you answer the question. You don't know. don't start saying irrelevant stuff. Then because the other lawyer or like me, I start getting a jump on it and take those and opens the door to something that is not even relevant, and you get impeached for it.
Yeah.
For no reason, and you're creating facts, or just not lying, but you don't even. But you feel obligation that you say yes or no. You see, you look at it, you say no or yes. You say no. The answer is I don't know.
Right.
You know,
right.
Why you are just feel the obligation that you have to say something.
Right.
That's so hard. That's the thing that the people, they have problem on the stand or witness stand or in the deposition, because they feel that they have to say something and they don't think. And the pressure of the camera in the deposition or the jury that are looking at you taking notes is going to freak them out.
Right.
And I had the worst one actually in Las Vegas, that the client started fighting with the defense counsel.
Literally fighting.
And the judge reprimanded her in front of the jury. That's a worse situation.
They're like arguing with each other?
Yeah. Over the thing. So even though we prepped her, I say, hey, never get into it. They try to poke you, trying to just instigate you to start something. Their job is to just say that you are not credible. Ask the jury not to believe what you are saying.
Right.
So don't get offended. But she got offended.
Has the circumstances ever been so intense in the courtroom where maybe you're talking about a kid that was killed or something like that, where you yourself, have you ever had to hold back tears while you're presenting a case?
I had some wrongful death, but the worst one was that it was in Las Vegas, that motorcyclist went under the trailer and was flattened completely. Okay, and you could see the face flattened on the thing and it goes nowhere. And that was a horrifying moment, actually, that I look at it and say, holy moly. That's not something, that's the reason we just put those photos, actually, as a ban, as to people cannot see it in the office, because there are evidence. Ultimately, the jury should look at it.
Right.
They have to see where it was impacted, and all the bodies under the truck, like actually, is grounded meat, actually, underneath. It's so dangerous. So, those are the things that sometimes is really horrifying.
Yeah.
Yeah. And
how do you keep it together?
I cannot say you get used to it, but you have to look at it.
Right.
And you have to just put
it's
it
like
there.
A doctor,
it's
right?
a doctor. You have to do it. Like the last podcast that we had someone that, what was the name? That was cleaning up the crime scene. Matt Montague.
Right.
Yes. And I asked him about the worst scene that he ever saw, and he started talking about that Texas case on our show, that the guy with the amphetamine cut the rib cage out of the mother, mom.
I mean, it's crazy, right?
It was crazy. So that's it. He had to deal with it. We have to deal. But ours is not at the scene, at least. It's the photos, it's the videos.
Right.
And that accident was captured on the dash cam. That's horrifying, because the 18-wheeler made a left turn by seeing that lights are coming. But he didn't stop in the pocket before making a left turn, blocked the entire Blue Diamond road, and this motorcycle hit the thing, and the top of the body came off and went underneath. Trailer ran over him, and the motorcycle all the way to 300 feet. He was speeding to some extent, but this trailer should not have made a left turn when they're seeing the lights are coming, because you cannot distinguish which light is faster than the other one when you are just, if you don't stop and you don't focus.
Yep.
And he didn't do it. He made a left turn right away. And you can hear the sound. It's a sound of the motorcycle under the trailer.
You had to play that footage in court?
You have to. Yeah,
right.
Yeah. Not yet, but...
Oh, it's coming up.
It's coming up. Yeah.
Oh, wow. So this is when did this happen?
Around last year.
Oh, wow. So when does that case happen?
It's last year it happened. We took over. Yeah.
Really? So it was with a different firm at one point?
Yeah, it was a different firm in town. And they didn't do anything in the case. And the truck was sitting over there for a year. And the client was pissed.
I feel like that might be your biggest case ever, no?
It depends on the liability. You have to go over the liability, because our client had the skid mark of the 100 feet. But it's still, the argument is, the driver should not have made a left turn. Right. 70 miles, 65 miles, or 90 miles. It's still this driver, this motorcyclist, was under the trailer or lost control. Something could happen to him. That's our argument.
Right.
Yeah.
And you going for millions?
Yeah, he was himself was a semi-truck driver, unfortunately.
The
He was
motorcycle rider was also a
yeah,
truck driver?
and owning a truck and working, 32 years old.
Wow.
Yeah, supporting the mom. Yeah.
Wow. So the
That's
mom's
sad.
going to, is that your
Mom
key
is the
witness
person
or one
key
of the?
witness, yes,
Yeah.
because he was supporting the mom and the family and the sisters.
Wow. That's heavy.
He
Now,
was the breadwinner for the family.
now, a case like that, is it just you that tries that case or you have?
Yeah, we have with my lawyers and in the office. Yeah, we do it. Yeah, but we develop the case. We have an expert to test actually the samples, do a lot of stuff. It's a lot of work.
Yeah.
From UC Davis are coming to just do it.
What's the biggest case you've ever had financially, like for the firm?
Financially, we had around $4 million settlement for myself, actually.
For you, your cut,
Yeah.
$4 million.
Yeah.
That's amazing. Is that so? When you win a case like that, did you know you were going to win? Like you felt like you were going to win it, and it was just a matter of how much.
You can see it when it's coming, but you know at the beginning that the case is a good case. Actually, you have the damages over there. You have a good plaintiff.
Yeah.
And you have a good witnesses. You have a good actually experts and the doctors. They did a good surgery, but there are disabilities, residual disability in it. Unfortunately, sometimes those are adds value to the case for the person for compensation. But also at the same time, it depends on the limit of the how much money the other party has.
Right.
Because I had the wrongful death, poor guy, run over by a kid that was going 70 miles in the area of the 50 miles or something on the crosswalk, killed the guy on point and flown him. But policy was how much in California? 15, 30. What you can do? Nothing. The guy doesn't have any assets.
So that's all it is?
That's all it is. That's it.
Wow. That was my next question. Is there's winning and then there's collecting, right? Those are two different
Collecting, you
things.
can collect. He files a bankruptcy and
Right.
it goes away.
You
It's
get a
negligence-
judgment that
it's
follows him, but-
It's a negligent conduct. You can just if you get the verdict, it still goes away with bankruptcy.
Is that why in a lot of lawsuits like that, like they name every possible entity they can, they name the city if they can, or whatever, the
It
company?
depends on the theory of liability. It depends on who is going to be potentially at fault because you don't want to miss the statute of limitation on those people. Later, if you find out, they can relate back and you can sue. But if they were known at the beginning of the lawsuit, you have to put all of them in. Later, they say, oh, you knew about these people.
Right.
Why? For example, in the medical malpractice cases, nurses and everyone in the room, that they wrote a note on the thing and they did some services regarding that, it should be sued. But it doesn't mean all of them, they did the wrong thing. After a while, possibly, you are going to dismiss this one, dismiss that one. And as long as you see the possibility of having one little liability on each of them, you have to put them, unfortunately, in the lawsuit. Otherwise, you are going to miss that opportunity for your client to bring them again.
So you've got the firm in LA, you got the firm here. You just bought this amazing building here.
Thanks.
Where the office in LA is the same kind? This is in like a traditional office building kind of.
No, we
kind of
are in
thing?
the high rise. We are leasing it over there. It's a high rise.
What part of town?
We are in
is-
Wilshire on Wilshire Boulevard.
Oh,
yes.
fancy. Like Wilshire and what? Wilshire Beverly Hills?
Wilshire, no, Wilshire and Normandy because it's
Okay, yeah, I
closer
know-
to
I
the
know down
downtown
there.
court. Yes.
Oh, right, because that makes sense near the
yes,
court.
on the Metroplex building.
So when you buy that building here and you've got your office there and you have all these employees, do you ever like look in the mirror and go like, I did it?
Yeah, at the same time, it comes with a stress. Some people think that having your own business or going solo or creating the law firm it's so easy and it gives you flexibility. Yeah, it gives you flexibility, but takes away all your 24 hours actually of the day.
Right.
You have to think about the cases even at night in the sleep sometimes.
Right.
Unless you don't want to just expand. If you want to expand and have more cases and care about your clients, that's hard. It's not something it happens overnight. It doesn't happen by just working 8 hours per day. Some junior associates say, hey, Sam, how you did it or how you deal with it. You send emails at night. Say, yeah, I send emails at night because I'm behind.
Right.
Yeah, at 1 a.m. I send an email, but it doesn't mean that you have to respond to it. But I'm as a manager, I have to just manage my firm because
Sure.
I'm responsible to many people.
Right. Right.
But they think that it's an 8-hour job. The attorneys, they don't have an 8-hour job. based on my understanding. Unless you want to do a pre-lit. If you are a litigator or you have a firm, or even you're working as associate sometimes, there is no 8-hour job definition unless you work for the entity or I don't know. It depends. But as a litigator, I haven't seen my friends or people that they were successful to say, oh, I go to work at 9, I come home at 5:30. And I'm going to close my laptop, I close my cell phone as a lawyer, and I expect to be successful. It's not going to happen.
That way. Yeah.
It doesn't work that way.
Do you ever take a day, just a Sam day, no work, no nothing?
For surgeries, yeah.
And now you got this new guy working for you, Dave Kohlmeyer.
Oh my God.
How's he working out? Is he doing it right?
He's trying to hang out.
Yeah?
Hang in there. No, he's cool. He's just streamlining a lot of work that operational wise actually for me, because those things are taking time and it's hard. And I'm doing it, but I'm still supervising because today I was saying this window should be this way. Say, it's good that you are here. Say, yeah, hello.
I like that you'll send him a text at 2 a.m. You working? And then you send him one at 7 a.m. Are you up? Are you working?
Do I see you by 7:30? And he responds. It's amazing.
Are you ever shocked? Like, what? I didn't think he'd be up.
I know he doesn't sleep. Actually, I know he's like me.
He wakes up in a panic and he's responding.
Possibly puts it on the special ringtone. It's honks. Sam is calling. And he has an automatic test. Yeah, I'm seeing you. Yes, it's cool. It's a bot. Yeah. Possibly he bought the bot actually or something to respond to me. I don't know. I'll have to check.
Well, man, thanks for
FaceTime me next time.
Right? Yeah. Well, thanks for having me on again. I already had respect for you, but when I went to the party last week, it really it's just you've really built amazing things, and I know it's a lot of stress, and
thank you.
I get it.
Thanks for support.
Yeah, man.
And also for this show.
Yeah.
And you're teaching me good stuff on the podcast.
I just got to get in the wife's good graces. That's my next goal, Sam. That's my goal for the year.
Go and talk to her. I don't know. I wanted to change this name. I don't know. We are good ranking and everything. So you are going to deal with that.
You're going to go home.
I brought her to just talk to you, and you sold me out.
I didn't know what was going on. I got bamboozled. I don't know. I feel like if I went to your house, somewhere there's my face and a dartboard, and she's throwing darts at me. I don't know.
I have to
Not
check,
yet.
possibly. Not yet.
Oh, man. All right. Well, that's good stuff.
We're out.
Okay. So thank you, and we will talk later.
It's over.